Hello, everybody. It turns out Donald Trump can't shut up to save his own hide. Forewarning, I haven't been following the civil trial, but news coming out about the civil trial with Donald Trump, the defendant, being on the stand. First of all, I don't know what attorney would want Donald Trump to be on the stand. And he effectively admits to having committed the financial fraud. Now, let's remember that this case, the civil case, the judge has already made a ruling, and now the hearing is about how much of a fine is to be imposed. And so I guess New York is giving Donald Trump the opportunity to asked for a lesser fine. It's not about culpability. And Donald Trump didn't get a trial by jury because he didn't opt for one. His lawyers didn't opt for one. So evidently, he got on the stand and he did everything for which any other person would be held in contempt of court and fined and or imprisoned. And then he went on to say that everybody in the Trump organization was responsible for the financial matters of the company. Sort of like a carte blanche. Yeah, we all did it together. Now, I don't know how that helps with valuation. I don't think that really will help the judge, who is the arbiter in this case, because there is no jury. It is just the judge. And then after the ruling, Donald Trump will most certainly appeal it. And then the highest court in New York eventually will get to that appeal. And they will look at the valuation, and then they will look at the fine, and whatever will happen with the appellate process. But what Donald Trump is being allowed to do, I was thinking, we talked a lot about the gag orders and everything. Maybe the prosecutors should just let Donald Trump spew whatever nonsense he wants to. Maybe he can go ahead and compromise the trial or compromise or corrupt the jury pool. That would give the prosecutors, Jack Smith and Fani Willis, the opportunity to, and in the civil case, Letitia James, the opportunity to ask for a steeper fine. In the criminal cases, can ask the courts to revoke the conditions of bond, maybe even remand him to custody to a certain degree, because when given the opportunity to do so, Donald Trump will always take the path of attacking. He will always take the path of being the aggressor rather than ever being, despite the fact that he's the defendant in all these cases, he will make himself the victim and then he'll make himself the protagonist to the court of public opinion. And that is why it's important to preserve the integrity of the court proceedings, because otherwise it would be exceedingly difficult for the court and the voir dire process, the jury selection process, to select a group of people who can render and who can deliver a balanced verdict on Donald Trump's guilt on those criminal cases. In this civil case, it's already taken care of. Donald Trump is not helping himself. I don't think Judge Engoron is going to give him the highest penalty, which is $250 million, which is $250 million. I don't think he will go that high simply because the appellate process is there. What I can tell you is that he will probably keep it somewhere in the 150 million dollar fine, so that there it's so that Donald Trump, when he appeals, doesn't sort of say that the judge abused his discretion in applying the law and gave sort of an exceeding of fine that did not fit the crime. Well, I mean, Donald Trump didn't help that case at all by being on the stand. So, you know, maybe his criminal gag order from that is now being stayed. We'll see if in the next 2 weeks he says something or not. Excuse me. He very well could. He very well might not. He already talked about the 60-minute interview about John Eastman and about the fake elector plan, and therefore, in many ways, the substance of what the case is going to be in the DC criminal conspiracy trial. But he has so far, meaning in the last 10 minutes that I have been recording this, has come out and said anything that would have violated the gag order had it been in place. He hasn't done that yet. But we have about 2 weeks. And my bet is still on him doing something that would violate the gag order had it been in place. And I maintain that the 11th Circuit made a mistake by staying Judge Chutkan's gag order without giving deference to Judge Chutkan's 9 page opinion explaining why she reimposed it. So if there is a case where he violates that, I think it would give the 11th Circuit room to even remand and tell the Judge Chutkan that, yeah, he has violated this order that we stayed, and so you can deal with him with prejudice, meaning, if there are any more frivolities, that the judge can go ahead and both sanction him financially or put him in jail. And what most likely would happen would be moving up the trial closer than March 4, 2024. So all these variables are out there. But one of the things that is for certain is that Donald Trump, when he speaks, he doesn't, or whether it be social media or on the witness stand, he doesn't think too much about what he's saying and the implications it might have. And that may very well bode well for prosecutors who clearly, would want to maintain the integrity of the case and safety of all the involved parties. But if they get this steep resistance, and if the Supreme Court says, no, this is a First Amendment violation, then they can just aggressively pursue everything he says as the whole anything that you say can and will be held against you in a court of law, because they already have. And I believe that should the Supreme Court, because all of these motions, these interlocutory motions, will be pushed to the Supreme Court. The Supreme Court likely will give them an appeal and bunch them all together, or maybe even reject some and hear some, and they will hear it together because they don't have the time or the patience to hear every single interlocutory appeal from a pre-trial motion in a criminal proceeding to come up to them in the effort to delay the set trial date of March 4, 2024. I would hope that the judiciary would see through that farce. And so that remains to be seen. Jack Smith has responded splendidly with each of these motions, these frivolous motions that Donald Trump has brought up, all the way from, having governmental immunity to First Amendment considerations to political persecution to the gag order being vague and overbroad, all of these things. So he keeps on mounting the pressure on the federal judiciary and the DOJ, and these motions will at some point be heard. Mike, it would just be very good for the interest of justice if the Supreme Court, in an emergency session, heard any appeal that came to them. And that if it is Jack Smith that appeals, that he bunched the appeals together as a package deal, because Donald Trump will likely appeal each of them individually, just because he wants to do that and delay more. And the Supreme Court must deliver its opinion before the set trial date of March 4, 2024. Judge Chutkan has set the jury selection questionnaires and all of that preliminary stuff for February 9th, I believe. So that process, Supreme Court, when they take those appeals of those interlocutory motions of criminal proceeding, need to give deference to the trial court that has the responsibility of getting through these pretrial motions and getting to trial and presenting to the fact finder, meaning the jury of Donald Trump's peers, with the evidence that is needed for them to determine whether or not he is guilty of a felony. And the public interest in knowing that is so much higher than any interest the defendant or anybody would have to not knowing the truth. Because we will be, if that were to be the case and Donald remains the nominee for the Republicans, that will be a determinative point for many people who will say, no, you've gone through the criminal jury process and you have been found guilty by a unanimous jury. Because that's how, that's how Donald Trump will be found guilty, if it is by everybody in the jury. So these are the protections that are built in for any defendant who comes in the criminal process of the American justice system, the federal jurisdiction I'm talking about. And he's been given more deference than anyone. And he has pushed the boundary more than anyone. So I would hope that the Supreme Court would take all these things into consideration and expedite their opinion. That way it comes before February, when Judge Chutkan has scheduled the jury questionnaires and all of that to start. And then March 4th 2024 being the trial date. I hope that the appellate courts give the fact-finding court the deference that the court deserves, and acknowledging the standard in jurisprudence that the trial courts are given broad discretion in how they handle the cases before them and how they manage the cases before them. Donald Trump has said nothing that would undermine that core principle in the judiciary. So with that, thank you so much for being here. If you like what you heard, please like, subscribe, and share. I don't see any questions. If there were any questions you may ask, then feel free. I don't see any questions. Please leave any questions you have in the comment box, and I will get to the questions and get back to you. And take care.